Our host for the event this morning. The permanent secretaries in the Federal Ministry of Justice and the Federal Ministry of Information and Culture and their present. The heads of the agencies of government, ministries, departments and agencies here present, distinguished members of the press. Let me begin by way of giving an insight as to the office of the Attorney General and by extension the Federal Ministry of Justice, which indeed is a constitutionally established office. Section 50 of the Constitution of the Federal Republic of Nigeria established the office of the Attorney General. And the section further stated categorically that the Attorney General is the chief law officer and minister in the government of the Federal Republic of Nigeria. The clear implication of Section 50 of the Constitution is to the effect that as the chief law officer of the Federation, the Attorney General is expected to provide opinion, guide government, and by extension of Section 174 of the Constitution, coordinate anything prosecution, particularly of criminal cases, taking place in the Federal Republic of Nigeria. But that function is not an open-ended function. The office of the Attorney General of the Federal Republic of Nigeria is expected to be guided by three cardinal principles in the exercise of whatever opinion, in perhaps the prosecution, in formulation of legal opinions, in supporting the legislative process by the National Assembly, and indeed in the enforcement and execution of laws that are in place by the Federal Republic of Nigeria. So the presentation we are going to make this morning by way of scorecard of the Federal Ministry of Justice is indeed a presentation that is rooted in policy arising from the fact that the Attorney General as a Minister of Justice is indeed involved in policy formulations of the federal government, in the execution of such policies and enforcement, among others, but then certainly in so doing, the actions and inactions of the office of the Attorney General are expected to be beclouded with the public interest, the interest of justice, and indeed the need to ensure no abuses are occasioned, both in policy formulations and indeed the dispensation of justice. So it is my privilege on this note to make this presentation on critical aspect of scorecard, reflecting the achievements of the office of the President of the Federal Republic of Nigeria in the area of reforms, administration of justice, anti-corruption efforts, and indeed promotion of the rule of law. The scorecard we are going to present in this regard is a scorecard that is going to be based, one, on the Ministry of Justice in its own right, extension, its association with the National Assembly and legislative process, its association with judiciary in the discharge of judicial functions, and indeed in the enforcement, application of policies of government, among others. So on this note, distinguished ladies and gentlemen, I would like to begin by way of presenting the scorecard of the federal government as it relates to Federal Ministry of Justice with particular regard to criminal prosecution. In conjunction with the relevant security law enforcement agencies, the ministry has developed a framework for joint investigation and collaboration geared towards engagement of prosecution, guided investigation in terrorism cases to address challenges of successful prosecution. A robust interface in that regard has been developed between the Office of the Attorney General and the law enforcement agencies for synergy and good working relationship in the areas of arrest, investigations, as well as case management. It also, as part of effort to enhance prosecution of cases prosecuted within the period under review, 3,000 terrorism cases, which were indeed profiled to date, out of which 1,500 cases were prosecuted, with 397 convictions secured relating to higher level terrorism cases inclusive of Boko Haram. A total of 7,000 cases involving various offenses including maritime, armed robbery, vandalization of electrical equipment and pipelines, financial matters, cybercrime, kidnapping and anti-corruption have been successfully prosecuted. I am talking exclusively on criminal prosecution, but I want to place it on record that there exists higher profile civil prosecution or civil matters that are as well prosecuted, and I will address you on that as well. The ministry is equally coordinating the next phase of terrorism-related trials in collaboration with the Federal High Court, the Legal Aid Council, and Defense Headquarters. So in this regard, the ministry is currently remodeling structures at the Royal Cantonment, Kenji, to accommodate 8 courtrooms, taking into consideration the fact that there is need for speedy determination of cases and there was shortage of courtrooms. We have taken steps to have in place 8 courtrooms, judges' chambers, living accommodation, lawyers' dressing room, and convenience to make them conducive for judges, witnesses, as well as defendants. The need to have a permanent structure arose on account of the fact that before now, what obtains in terms of terrorism and Boko Haram cases was an ad hoc arrangement. An ad hoc arrangement of moving judges from jurisdictions to a particular location will then now permit prosecution to hold. And whenever they are demobilized, the idea of mobilizing them back to site has become a problem. And out of the need for speedy determination of these cases, the volume of cases, and the need for efficient justice delivery system, the President of the Federal Republic of Nigeria considered the need to have permanent structures in place associated with the prosecution of terrorism cases, and that is what indeed brought about the need to have permanent structures, and the project has indeed advanced. Has indeed advanced. So what I'm saying in essence, the intervention of President Muhammadu Buhari is not only about the prosecution of cases, but providing the necessary structures to ensure sustainable arrangement and not indeed an ad hoc arrangement for prosecution of terrorism cases. Again, of recent, we were faced with the issue of sexual and gender-based violence. And then the need arose for speedy intervention, and the President of the Federal Republic of Nigeria had indeed lived up to the expectations of the public in addressing the scourge that has manifested itself. So in response to the growing incidence of sexual and gender-based violence in the country, the President directed the establishment of an inter-ministerial management committee on the education of SGBV cases. Further to this, the ministry has established the SGBV response unit, which activities have yielded the following successes out of desire to address the problem. 1. Facilitation of access to justice for the victims of sexual-based violence through prosecution, legal counseling, and negotiation of settlement agreement between parties on primary law issues with focus on protection of rights of women and children. 2. The establishment of robust referral mechanism with relevant key MBAs and stakeholders, which has as well been put in place. 3. Strengthening of the knowledge of the sexual gender-based violence cases through capacity building programs and indeed designation of 4 courts on SGBV by the Chief Judge of the FCT. So what I am trying to say in essence, the government's arrangement, the government's focus of President Muhammadu Buhari is responding with a greater speed to any issue that arises within the justice sector, so as to bring about speedy, special consideration and speedy determination of cases involved therein. Now, again, a major issue of intervention in respect of which the government of President Muhammadu Buhari considered the need for exceptional and speedy intervention is the issue of anti-corruption drive. As at the time we came in as a government in 2015, there was no in place national anti-corruption strategy. There was the anti-corruption project, no doubt, but the strategy that can now translate to effective successes in addressing the problems of anti-corruption was not in place. As at the time we came in place, for example, agencies of government, if I may cite an example of one, for example, the EFCC, ever since its coming in place to 2015, only succeeded in prosecuting or securing 103 convictions. Within this year alone, arising from the strategy that was put in place by the government of President Muhammadu Buhari, has succeeded in securing over 3,000 convictions within a year. So it was against the background of the realization that there was need for a policy that brings the anti-corruption agencies together to work together on the basis of a targeted policy arrangement. The government of President Muhammadu Buhari put in place national anti-corruption strategy, which has as well been renewed in 2022 to 2026. So the government has pushed the frontiers in the fight against corruption in several areas by strengthening anti-corruption agencies and accountability system, passing strategic anti-corruption legislation and enforcing sanctions with vigor. A major positive development in the anti-corruption agenda is the adoption of the National Anti-Corruption Strategy. The National Anti-Corruption Strategy was first adopted by the Federal Executive Council in July 2017, planned for a period spanning 2017 to 2021. The National Anti-Corruption Strategy implementation has now been extended, realizing the advantages associated with it, has now been extended from 2022 to 2026. The strategy seeks to develop and implement mechanisms aimed at improving governance of public institutions at the federal, state, and local government levels by converting corruption-related factors inhibiting government capacity to deliver quality services to Nigerians. Corruption is indeed identified as a major issue that constitutes a serious setback to development. If only the government of President Muhammadu Buhari could now deliver on its mandate of provision of infrastructure, checkmating the menace of corruption, it is only logical that the strategy should be put in place. And with the strategy in place, a lot of successes both in terms of prosecution, in terms of nipping the corrupt activities in the VAT, in terms of international recoveries were indeed achieved. So, the National Anti-Corruption Strategy also has a monthly evaluating committee established by the Honorable Attorney General of the Federation Minister of Justice, comprising of 22 members drawn from different sectors, including state and non-state actors, with the technical unit on governance and anti-corruption reforms, TUGA, as the secretariat. So we have not only developed anti-corruption strategy, but created a secretariat for monitoring and implementation of the strategy. So the Monitoring and Evaluation Committee has the responsibility to monitor, evaluate the progress made on the implementation of the anti-corruption strategy and propose suggestions inclusive of amendments or perhaps putting in place new legislations that could now enhance the quality of what we are doing in terms of the fight against corruption. So what are the successes that have now been recorded arising from the national anti-corruption strategy put in place? The implementation of the strategy is ongoing and modest achievements have so far been recorded. There is increased transparency with the growth of initiatives like Freedom of Information Act, beneficial ownership disclosures, and open contracting, among others. Routine corruption risk assessments are carried out to determine vulnerabilities to corruption, including systemic reviews to tackle anomaly from the roots. There have been continued efforts strengthening dedicated institutions to ensure data policy nexus and interagency coordination and collaboration, especially via the interagency tax team of anti-corruption agencies platform. Now, arising from the successes of the anti-corruption strategy put in place, we have succeeded in coordinating national and international collaboration and cooperation among institutions, both local and international institutions of government, and that effectively translated to the recovery of looted assets. So in line with the principle of the proven administration and the fight against corruption, we have achieved the following successes under the asset recovery and management effort of the administration. Let me state, for example, that in 2017, we have succeeded in recovering $322 million from Switzerland, which was indeed recovered and repatriated asset. But then, taking into consideration the good governance approach and arrangement of the President Muhammadu Buhari, what was that fund recovered in 2017 used for? The President of the Federal Republic of Nigeria, President Muhammadu Buhari, realized the need to checkmate the inherited poverty. As at the time we came in place as a government, poverty was visible everywhere. And the need to checkmate and address the poverty became a front-runner issue of the administration of President Muhammadu Buhari. So the $322 million that was recovered then was deployed in the social investment program of the federal government. So what is it? What were the successes recorded arising from the social investment? First, You have, as of today, what we call Ministry for Humanitarian and Disaster Management Affairs put in place. The ministry has succeeded in having an power program, a lot of other interventions inclusive of the school feeding program, programs that are targeted at public works support, and a host of other programs that have been adjudged the best in the history of Africa, arising from the direct support to the poor in the segment of our society of today. That program, social investment program, is rated the best in all of Africa. Now, in 2020, again, we succeeded in recovering additional $311 million from US and Jersey. What was these funds applied for? Arising from the international understanding, the federal government deployed that amount of money in strategic infrastructural development in this country. What projects were they? We have Lagos-Ibadan Expressway, Abuja-Kano Expressway, and second, Niger Bridge. So for those that care to know where your money recovered were indeed deployed, I am putting it to you that the first tranche of 322 million was applied for the benefit of the poor. The second segment was applied for infrastructural development in this nation. And what we are witnessing today at the second Niger Bridge is indeed a product of the repatriated funds that were recovered by the federal government and indeed deployed for that purpose. Locally as well, we equally recognized that over time there were a lot of assets that were recovered through judicial process by way of forfeited assets. But those assets have been littered all over the place across the country without any effort put in place for the purpose of ensuring that those assets were disposed and indeed applied to meaningful development of the government. So what is it that we do in that respect? The need for institutionalization of the disposal of recovered assets came in place. And we took steps arising therefrom to initiate what is called Proceeds of Crime Act. Proceeds of Crime Bill that eventually translated into Proceeds of Crime Act. The spirit, essence, and purpose of that act was indeed to institutionalize the disposal of assets by the federal government. And then, what happened? That bill had eventually been passed, and then it became a Proceeds of Crime Act. Only last 2 weeks, the institutions of government arising from the application and the enforcement of the Proceeds of Crime Bill had taken steps to dispose assets. Automobiles were disposed of recent through a transparent process as established and enshrined by the Proceeds of Crime Bill Act by the EFCC. Additional assets, that is immovable assets, landed properties, were equally disposed. So we have not only realized the need to recover assets, but to institutionalize it through a transparent, open and legislative process. So arising from that, for example, the Office of the Attorney General as well took steps to ensure the disposal of the assets that came its way and then initiated a process. So as it is, a total sum of 1,823,783,146.86 kobo has been generated so far by the Federal Ministry of Justice from the forfeited properties. So again, further and over and above what has been recovered at the international level, which I have taken offense to state earlier. We equally, in compliance with the presidential mandate and foreign judicial processes, the Ministry of Justice has equally recovered the total sum of 6,324,627.66 pounds from various jurisdictions, some of which recovered funds are being utilized in financing critical infrastructure, including Abuja-Kano Expressway. But an information that I think is equally relevant for your consideration is the coordination of the Office of the Attorney General and Minister of Justice as it relates to critical infrastructure. The Lagos-Ibadan Expressway, Second Niger Bridge, and indeed Kano-Abuja Expressway experienced a funding gap of recent, on account of which we experienced some slow phase of progress of work because the contractors were looking for money, and then there was immediate need to address the funding gap associated with that project. So what happened? The Office of the Attorney General coordinated the law enforcement agencies for the purpose of identifying the forfeited assets in the system. And these agencies have provided the desired support in addressing the funding gap. So what I am saying in essence is to the effect that the government of President Muhammadu Buhari has indeed understood the techniques, mechanics, and needs for good governance and understood the dynamics of using the system of the ministry, department, and agencies of government for the purpose of addressing whatever challenges that comes around by way of either intervening through legislative process, policy decisions, or indeed a collaborative local and international actions for delivery of good governance. Now, due to the concerted effort of the Office of the Attorney General in conjunction with the relevant stakeholders, including the legislature, the President recently, as I stated earlier, assented to the Proceeds of Crime Recovery and Management Act 2022 on the 12th day of May 2022, and that is what is now laying foundation for efficiency in the management of the looted assets. Other anti-corruption legislation that we have taken pains to bring about out of desire to ensure the success of the anti-corruption drive of the federal government include the following: Money Laundering Prevention and Prohibition Act 2017, Nigerian Financial Intelligence Unit Act 2017, Mutual Legal Assistance Act 2018, Company and Allied Matters Act, Incorporating Beneficial Ownership 2020, Terrorism Prevention and Prohibition Act 2022, Witness Protection and Management Act 2022. So our approach as a government to the fight against corruption is an approach of covering the field. When now we realize the need to have an effective money laundering prevention and prohibition strategy, we now first Money Laundering Prohibition and Prevention and Prohibition Act 2017. When we realize the need for international dimension to visibility of the fight against corruption, identification of the looted assets at the international level, we came about with the Nigerian Financial Intelligence Unit that makes Nigeria a party to international visibility of the financial dealings across the globe. And that has assisted us greatly in not only identifying looted assets of Nigeria, but working towards the direction of pursuing them and returning them back to Nigerian state. Now, we equally were faced with a problem whereby Nigerians perhaps takes out assets, Nigerian assets, unlawfully. And then we equally have to seek for the understanding and collaboration of the international community for the purpose of ensuring that this asset is returned back. But you can't do it on your own out of the blues, unilaterally. And that now prompted us into having what we call Mutual Legal Assistance Act 2018 that will allow us to have a legislative support for engagement of the international community to ensure at the end of the day that we work with them, engage them, and have our assets back. Again, in terms of the ease of doing business, support for international investment to the country, the need arose for amendment to the Companies and Allied Matters Act. And then we equally took steps to ensure that our CAMA, the Companies and Allied Matters Act, is indeed enhanced both in quality, in quantity, and in line with international best practices for the purpose of attraction of the international investment. But then there is a major challenge that reared its head in the art of governance shortly after the government of President Muhammadu Buhari came on board. What challenge is it? Security challenge. As at the time the government of President Muhammadu Buhari came in place as a government, about 17 local governments in a state, Borno State, were in the hands of Boko Haram. And then we were faced with the challenge of how best to address it. Among the major issues of consideration was to have military hardwares that could be used in decimating the Boko Haram. Steps were taken to eventually acquire military hardwares inclusive of Super Tucano aircraft meant for use in decimating Boko Haram. But we are faced with a problem, and that problem is legislative, which is a problem that only terrorist designated groups can be attacked using Super Tucano even after they were procured. And then the need equally arose to enhance our laws on terrorism, among others. So what steps is it that were taken by the government? We now realize the need to amend and come up with Terrorism Prevention and Prohibition Act 2022. And that legislation was passed into law. Super Tucanos were deployed, and then arising from that, we equally take necessary judicial steps to declare the bandits, to declare Boko Haram, to declare IFOC as terrorist organization, and that lays foundation for justifiable, legitimate application and deployment of Super Tucanos in checkmating terrorism. So what is it we are hearing today? Today, arising from that piece of legislation, the Terrorism Prevention and Prohibition Act 2022, we are no longer witnessing a day in, day out report of bombings across our markets, churches, and mosques. Are we? We are certainly not. So, as it equally relates to policy decisions with particular regard to transparency in dealings, Nigeria equally joined international community of nations in the Nigeria Open Government Partnership. Trade and associated incidences require some level of transparency, accountability for the purpose of inviting or attracting investors. Only those nations that are signatories, members to Open Government Partnership are indeed committed to operating an open trade arrangement which naturally attracts investors. So with that in mind, the present administration's commitment to a full-scale anti-corruption agenda was accentuated in July 2016 when Nigeria joined Open Government Partnership as the 70th country, which at the end of the day translated into the ranking, perhaps the enhanced ranking of Nigeria, I believe by over 10 points, as being a major destination of choice in respect of which ease of doing business is imbibed as a culture. So, arising from that, Nigeria has as of today, is as of today rated as a destination that invite a culture of fiscal transparency in business, extractive transparency, anti-corruption, access to information arising from the Freedom of Information Act, citizens' engagement and empowerment, inclusiveness, and service delivery. The Federal Ministry of Justice, Finance and other relevant MDAs are providing the required leadership and implementation framework through the National Steering Committee and OGP Secretariat. Furthermore, the Federal Executive Council in June 2018 approved measures briefing the reforms of the OGP process and also ensure ministries, departments and agencies of government set up an OGP unit. The federal government of Nigeria, in conjunction with the World Bank, has also extended support to the states to adopt and domesticate the OGP fiscal transparency and sustainability initiatives through the state fiscal transparency, accountability and sustainability program. Again, by way of good governance, the administration of President Muhammadu Buhari has considered not only the OGP, not only the legislative framework, but litigation in its own right. How do we deploy the litigations? How do we litigate for the purpose of impacting on the economic well-being of the nation? An effective justice system is measured not only by the number of cases which are successfully disposed of, but also, and more importantly, strategic measures which are adopted to avoid litigation. In the first place, is it a combination of effective defense strategies to cases, including arbitration, mediation, as well as prosecution of appeals? The ministry has succeeded in saving the country from huge avoidable debt liabilities. A total of 648 cases were instituted against the President, federal government and the agencies before. Sorry, thank you. So a total of 648 cases were instituted against the President, the federal government and the agencies. So the cases are at different stages of trial. Diligent defenses of these cases in the year 2022 alone saved the government from huge debt liabilities to the tune of 142 billion 458 million 343,888 naira 52 kobo. These cases were handled in-house by the State Council employed in the Federal Ministry of Justice, and those saved Nigeria from huge liabilities that will have accrued from the payment of external solicitors' fees. So what I'm saying in essence, first we saved the government over 142 billion liabilities, and two, we saved the government from the payment of incidental professional fees that could have been paid to the external lawyers, arising from the fact that we have succeeded as a system in building in-house capacity in the chambers of the Attorney General of the Federation. Again, The ministry also coordinated the defense of number of international arbitration proceedings commenced against the Federal Republic of Nigeria and other federal government agencies. These include arbitration initiated by the Sunrise Power over the Mambila Power Project, EMI and Shell over the operational rights. We have also made appreciable progress in actions being taken to challenge the arbitral award in the case of proceeds and industrial development, popularly known as P&ID. The hearing of the Federal Republic of Nigeria's application to set aside the arbitral award will commence before the English court separately. But usually, it is equally important to mention that the case of P&ID involved an arbitral award of over $10 billion against Nigeria. As at the time we came in as a government, what was in place is a threat for enforcement of the payment of the arbitral award. We have succeeded, one, in filing an application out of time, simply because at the time we came around on board, we were about 2 years out of time in appealing against the decision. We filed an application and procured an order allowing us to appeal out of time. We filed an application for setting aside, for staying the execution of the judgment, enforcement of the judgment against the assets of Nigeria, enforcing the judgment of 10 billion. We succeeded in securing an order for stay of execution. We were asked to deposit 200 million pounds as a condition for the grant of stay. We appealed against that order, and then we were equally granted an order that we do not have to deposit the 200 million pounds as a condition for stay execution, among others. For your information, the main hearing is fixed for 16th January, and we need your prayers and support in that respect, among others. So again, if you may recall, the P&ID case was a product of flow-in agreement. An agreement was entered between Nigeria and P&ID for the supply of gas relating to a facility that was to be put in place by P&ID. But that agreement, unfortunately, was skewed against the interests of Nigeria. It was not an agreement that was substantially addressing the interests of Nigeria, but perhaps an agreement that has indeed factored more the interests of P&ID. So what is it that we do as a government to ensure that no such incidents occurs? The Office of the Attorney General developed greater capacity. And then contract negotiations, agreement, and international relations were equally considered as areas in respect of which we need greater capacity building. So vetting of contracts and approving them became a major issue over which capacity was built in the Office of the Attorney General. So the ministry has, in that respect, within the period under review, vetted and reviewed 965 major contracts and PPP projects to ensure value for money, sustenance of the public interest within the context of Section 175 of the Constitution, which bears the responsibility of the custody and protection of the public interest in the Office of the Attorney General of the Federation. So, with that, a total of 879 legal opinions were equally preferred during the reporting period for the purpose of guiding the ministries, departments, and agencies of government in arriving at lawful and legal decisions relating to the services, to the actions and inactions of the agencies of government. Again, the Office of the Attorney General, as I stated, considered and factored the need to attract investors in Nigeria. So that makes ease of doing business a necessary considerable factor in the exercise of the functions of the Office of the Attorney General. So the ministry has streamlined the guidelines for the incorporation of companies limited by guarantees with a view to stimulating economic growth. And arising from that, a total number of 2,679 approvals for the registration of companies limited by guarantee have been issued by the Office of the Attorney General. Again, in terms of negotiating and facilitating non-facilities on behalf of the federal government, the tradition is established internationally by international best practices that no financial institution in the world could offer or grant any loan to any government internationally without recourse to a legal opinion provided by the Office of the Attorney General in support of such loan facility. So the Office of the Attorney General provided legal support during negotiations for loan facilities for international organizations, including the World Bank, African Development Bank, among others. And our efforts so far have ensured that these loan agreements do not impose onerous conditions of government, which may in turn lead to additional liabilities. Again, arising from what was observed as it relates to the agreements and contracts being entered by ministries, departments, and agencies of government that often the federal government to unnecessary litigations, we have taken a decision of recent of the establishment of contract administration system, which is indeed a system that ensures the development of a check line arrangement for the federal government contracts to ensure at the end of the day no compromises are allowed by ministries, departments, and agencies of government that could be injurious to the interest of the federal government. So the federal contract administration system has been introduced by the federal government to effectively monitor contracts from MDAs from project conceptualization, award to final execution. In view of the numerous litigious contracts entered into by MDAs in the past, which have often led to higher project failures, project cost overrun, dispute, litigation, arbitration, and losses running into billions of naira and United States dollars, among others. So the Federal Executive Council, this contract administration system was presented before the Federal Executive Council for deliberation consideration, and the Federal Executive Council Council memo presented number EC 2021 at the 15th meeting, conclusion 4, directed the Honorable Attorney General and Minister of Justice to develop and establish the Federal Contract Administration System. The Federal Contract Administration System Solution is a digital platform designed to protect government from entering potentially flawed and unfavorable contracts by ensuring compliance with extant laws. The managerial administration of FICAS is warehoused in the Federal Ministry of Justice. Again, at the international level, we come to understand that as a country, as a government, we cannot be operating in silos. International collaboration, international cooperation is a key to what benefits you can drive onto your country. So the ministry has continued to work towards improvement in bilateral relations with other nations through the preparation and vetting of agreements, memorandum of understandings aimed at attracting foreign investments, among others. In July 2022, oil and gas related matters were negotiated and relevant instruments executed during the visit of President Muhammadu Buhari to Spain and Portugal. Nigeria also negotiated and signed agreements, memorandum of understanding with Ivory Coast, Burundi, Rwanda, Turkey, South Africa, Iran, Benin, Netherlands, United Arab Emirates, South Korea, among others. All these international agreements are intended to attract investment and indeed establish a relationship that is beneficial to Nigeria. Again, we have equally, along the line, looked into the need to enter into international treaties on security, among others, taking into consideration the security challenges that were posed onto our nation. So a few weeks ago, the Federal Ministry of Justice facilitated the ratification of Nigeria's accession to the Budapest Convention on Cybercrime, which was assented to by President on the 4th day of July 2022. Just like the Financial Intelligence Unit Act that gives us an opportunity to engage internationally and have some international visibility on the financial system, the Budapest Convention is equally a convention, a community related to certain countries of the world that come together for the purpose of sharing a platform of cybercrime visibility with a view to enhance what we do in the fight against terrorism and insecurity. So this, the Budapest Convention on Cybercrime is the sole international instrument on cybercrime which sets out the framework for harmonizing criminalization, procedural powers, and international cooperation, all of which serve Nigeria's strategic international interests in the fight against cybercrime and align with the national cyber security strategy in 2021. As we rightly know, in 2021, the federal government had in place National Cyber Security Strategy of 2021. But for us as a government, to enjoy the maximum benefit of it, it is only logical that we should engage internationally. And that is what informs our subsequent decision after passing the National Cyber Security Strategy 2021 to now indeed ratify the Budapest Convention on Cybercrime. Now, again, in line with our international engagement for the purpose of attracting benefit onto the nation, the need, as I stated earlier, came about for us to have Mutual Legal Assistance Act, which I have stated earlier. It is a legislation that allows Nigeria to engage with international community for the purpose of getting international support and then for the purpose of extending same. So arising from that law, the legal space, Nigerian legal space, is now open internationally for engagement. So the Office of the Attorney General has, as a result, executed over 350 mutual legal assistance requests. When we now have Mutual Legal Assistance Act in place, international community arising therefrom can now approach us for mutual legal assistance request. What do I mean? For example, perhaps if someone absconded from a foreign country to Nigeria, Nigeria can legitimately, arising from the mutual legal assistance request, receive a request, process them, and ensure extradition. So, with the Mutual Legal Assistance Act in place, Nigeria received 350 requests, and over 50 extradition requests were equally received by Nigeria. Among these are the Mutual Legal Assistance requests from the United Kingdom on trafficking in person, which as a result led to the first conviction of the offender under the UK Modern Slavery Act of 13th April 2022. Arising from the Mutual Legal Assistance Request Act, UK approached Nigeria over someone that is engaged in trafficking, and Nigeria legally supported UK. And the first conviction recorded by UK as a nation was on account of the support provided by Nigeria to convict someone that is involved in human trafficking. So this is the implication. Again, I spoke earlier in passing on legislative reforms. I have taken pains to explain to you how legislations could support the act of good governance, and cited an example just now relating to mutual legal assistance request, cited an example on terrorism, among others. So with that in mind, Nigeria equally require the administration of President Muhammadu Buhari saw the need to address certain challenges that were as well inherited. Among those challenges, as you rightly know, was the issue of congestion in our prisons formation there. As at the time we came on board, the noise was all over the place that our prisons were indeed highly congested. I believe it's no longer the case. Nobody is making the prison congestion as an item, not even in social media space. How do we address that problem, and what is it that we achieve therefore? We now came up with Nigeria Correctional Service Act 2019. And by that act, new innovations into the Correctional Service Administration were brought into place. For example, before coming in place of the 2019 Act, there is no discretion on the part of the prison formation to receive inmates. Once someone is sent to the prison formation, if the capacity of the prison is perhaps 1,000 people, and then 500 people are sent to the prison, they can never say no. The implication of that now is that the prison formation can now say no when the capacity is reached. That is one of the innovations going forward that stopped the congestion in the prison. And then what do we do to support that arrangement further after the act was put in place? We now took steps to put in place a presidential committee on decongestion of prisons, which committee now went round the country to ensure at the end of the day that those awaiting trials are being addressed, and ensure at the end of the day that a lot of people working with the government are indeed taken out of prison, provided they fall within the ambit of those that could be considered. At a stretch, one single prison visit encouraged by the federal government, working between with the Kano state government, over 500 people were taken out of prison. And in consequence of that arrangement, working in collaborative way and manner with the states, we have succeeded in decongesting our prison formation. I have stated how the Money Laundering Prevention and Prohibition Act supported what we are doing. It is equally a legislative intervention. Terrorism prevention, you are living witnesses to the fact that at a point, certain Nigerians were convicted in Dubai on account of the use of our financial institutions to fund terrorism, on account of which over 200 people were eventually arrested and being investigated relating to funding of terrorism. The amendment effective to the law in 2022 was indeed a product of that realization and the need to enhance what we are doing. Well, my attention is drawn that I have 10 minutes, but certainly I will not be done by 10 minutes. I will continue talking because the day is wide. So, again, we are equally faced with a lot of issues relating to deepening our democracy. In relation to the democratic culture and deepening our democracy, we were living witnesses to what was unfolding, but with particular regard to the speedy determination of pre-election matters, among others, and a lot of innovations that came about in respect of which we feel as a government that deployment of technology into our democratic culture could now enhance the quality of what we can do in terms of the election and electioneering process. So as a result of that, we took steps to come up with Electoral Act 2022, which indeed accommodated a lot of innovations in that respect. But then, by way of policy decisions also, we considered the need to come up with executive orders. For example, as at the time we came on board, there were high-profile corruption cases that had been stagnated, that were not moving an inch in terms of progress for over 10 years before the government of President Muhammadu Buhari came on board. And then we have the need to ensure that these cases are speedily consummated. So what is it that we do? Administration of Criminal Justice Act was indeed vigorously deployed in terms of application and enforcement. But then we went further to support that process by way of having in place Executive Order number 6. What is Executive Order number 6 meant to achieve? Those that were accused or were standing trial for high-profile cases, for example, could be charged with a case of looting perhaps 10 million naira. While the case is on, they remain in custody of the 10 billion naira, using part of the proceeds to undermine the investigation, to undermine the prosecution, and then moving around all over the place. So we now came up with Executive Order number 6. First, to ensure that their freedom of movement is restricted while they stand trial. Two, to ensure that access is no longer given to the 10 billion naira in respect of who they are standing trial. And with the speed of light, cases continue progressing speedily, on account of which, as of today, we have recorded over 3,000% convictions in respect of higher profile cases associated with corruption. So it is with that in mind that we realize the need to have legislations in place, and then we, as a result, come up with Money Laundering Prevention and Prohibition Act 2017, Nigeria Financial Intelligence Unit Act 2018, Mutual Legal Assistance Act 2018, Company and Allied Matters and Incorporating Beneficial Ownership Act 2020, Terrorism Prevention and Prohibition Act 2022, Witness Protection and Management Act 2022. So this indeed gives a background of the way and manner the office of the Attorney General is used, and indeed came up to support good governance and indeed service delivery as to what we are doing as a government. I will try to invite the spirit of summary towards a conclusion in view of the constraint of time. So, with that background in mind that has been established, I will now take you through some of the reforms that have emanated, arising from the international collaboration, legislative interventions, and indeed general justice sector appraisal. By way of justice sector reform, we have put in place the establishment and presidential committee on correctional reform and decongestion, and that was indeed what gave rise to the decongestion of correctional service formation. Again, we have put in place a review of postal institutions and remand centers, CAF, B1, laws of the Federation in Nigeria. We do not have in place a postal institutions arrangement that is effective. As as a result of which children and young persons are equally being subjected to correctional service formation, which is indeed in breach of international practices associated with it. So we have equally factored that in place, and then reforms are being put in place in that regard. Again, out of the need and desire to sustain reforms in the justice sector, we equally establish Administration of Criminal Justice Monitoring Committee, and it is what we are witnessing by way of having these legislations, these international collaborations, who are all product of the day in, day out suggestions, opinion, observations, and contributions of these agencies. So custody management project is equally put in place. Promotion of human rights as a culture too was part of what we do as a government. So, for example, out of desire to ensure at the end of the day to support people, regain their freedom and get back to society to contribute meaningfully, the presidential initiative associated with the prison decongestion, for example, had taken steps to indeed pay fines for some of people that are deserving. And indeed, for the first time in the history of Nigeria, the federal government under the leadership of President Muhammadu Buhari had taken steps, for example, to recognize Human Rights Commission, their determination and indeed opinion and position. It used to be a dog that only bites, that only barks and never bites before the coming in place of the President Muhammadu Buhari. What happened thereafter? If you could recall, there was an incident of Afro 6, I think it's called, in respect of which security agencies were alleged to have killed some people, about 6 of them, and then it became an issue for determination of the Human Rights Commission. And the Human Rights Commission eventually decided against the federal government, and the federal government now indeed paid a compensation of 135 million for the first time ever in the history of Nigeria, and for the first time in the history of Human Rights Commission. This establishes a culture of respect, not only for the institutions, but indeed for the human right. Again, we equally put in place a committee against torture. Nigeria recognizes the human right, and then arising from that, put in place all the necessary facilities to ensure respect for the human right. So in line with the international obligation, the National Committee Against Torture was reconstituted with higher level representative or relevant agencies. Again, we equally have in place the United Nations Universal Periodic Review of the Human Rights Situation in Nigeria, for us to be having a periodic report on what we need to do to enhance our human rights culture. Again, we equally have some interface with the judiciary, an account of which we have some judicial intervention. The ministry, in conjunction with the judiciary, supported development of certain practice direction for the speedy dispensation of justice in criminal matters. So the Federal Ministry of Justice supported the Federal High Court practice direction on trial of terrorism cases, FCT practice direction and guidelines on trial of sexual gender-based cases and ancillary procedure 2022, and equally realizes the need for enhanced welfare in the judicial system. So the Committee on Review of Judicial Salaries and Conditions of Service was impaneled in 2018 by the Attorney General out of the keen desire of the President to ensure that the nation's judicial officers received appropriate remuneration. And Mr. President has equally given approval in principle that the welfare of the judiciary entirely should be enhanced, and the Revenue Mobilization Commission is indeed working in that direction. So in the interest of justice, which is what the Federal Ministry of Justice stands for, I think it is equally logical that I should extend this presentation to what ministry, departments and agencies of government under the supervision of the Office of the Attorney General have been doing as it relates to the justice sector delivery. I will start with the scorecard of the NDLEA, Drugs Law Enforcement Agency. I think it goes without saying that they have indeed recorded extraordinary successes in the fight against drug addicts. So the effort in drug control by the National Drug Law Enforcement Agency was greatly increased from 2015 under the leadership of President Muhammadu Buhari. The agency has struggled to keep abreast of narcotic control measures amidst various challenges, which ranges from poor funding, dilapidated structure, very low manpower capacity, lack of operational vehicle, among others. So the government of President Muhammadu Buhari has supported the agency, and within the period under review, over 15,000 additional workforce has been added to the agency. They have indeed shifted grounds from peddlers of drugs to barons, and what we are witnessing today is indeed great effort on the part of NDLEA in terms of checkmating, apprehending, investigating and prosecuting drug barons as against the petty peddlers of drugs. Before proceeding to the next agency, let me perhaps maybe give an insight as to what they have done in terms of arrests and seizures. Between 2015 and 2021, the agency made a total of 68,540 arrests, and within the same period, there were seizures of various hard drugs amounting to 3,136.166.59 kilograms, a total of 546.81 hectares of cannabis farmland were also destroyed. So in terms of litigation as well, in 2015 there were 1,690 convictions. In 2015, 1,256 convictions were secured. In 2017, 1,620 convictions were secured. In 2018, 1,220 convictions. In 2019, 16,554 convictions were secured. And in 2020, 2,348 convictions were secured, while 3,263 cases are pending. So I think it's equally important to proceed to NILS, Nigerian Institute of Advanced Legal Studies. The institute has continued to deepen engagement in capacity building. It is an institution that is responsible for capacity building. Without the institution, the Nigerian Institute of Advanced Legal Studies supporting the capacity of what we are doing, the idea of improving on the convictions from 103 to 3,000 by an agency would translated to over 3,000 enhancement in conviction couldn't have arisen. So the government supported the Nigerian Institute of Advanced Legal Studies, which is in place for the purpose of enhancing the capacity of our judicial officers and prosecutors, for the purpose of ensuring at the end of the day that they support with speed the process of adjudication. Regional Center for International Arbitration, also the center caters for the needs of arbitration communities in the areas of provision of arbitration services, facilities for arbitration and other ADR methods. The Nigerian Law Reform Commission is equally working in the direction of looking into the legislations. I have stated in my earlier submission that a lot of legislations were indeed put in place by the government. The responsibility of working in the direction of having enhanced quality legislation is that of Nigerian Law Reform Commission. Legal Aid Council, working with the Human Rights Commission, also provide a lot of support services to those that could not afford the legal services. Out of compassionate consideration of President Muhammadu Buhari, he insisted on the amendment to the law relating to legal aid counsel to make it more meaningful and more supportive. There are those that are charged before the court that could not afford the services of lawyers. So what is it that President Muhammadu Buhari did out of compassion? Is to strengthen the legal aid counsel to support those type of people. And arising from that, about 57,134 students in the remaining cases were completed by legal aid counsel, which were support services, and then they recovered the sum of 57 million as claims and compensation for victims of motor vehicle accidents that could not afford the services of lawyers. They equally provided defense for about 224 suspects arraigned before the Federal High Court for the offenses of terrorism. There are people that were charged with terrorism that could not afford the services of lawyers, and they provided the services and supported about 224. They constituted a special task force to speedily handle the cases, and this led to the recent release of 30 awaiting trials from Kefi Correctional Service Center. They filed application for enforcement of fundamental rights of about 101 awaiting trial inmates, and equally who have been in prison custody for a longer period of time, among others. I am also pleased to report that the police duty solicitor scheme currently operates in 11 states across the country, including Kaduna, Ondo, Imo, Sokoto, Federal Capital Territory, Kebbi, Edo, Bayelsa, Rivers, Nasarawa, and Plateau State. This operation has successfully diverted over 7,000 persons from the criminal justice system, and 90% of this number left custody of the police within the first 5 days. Council of Legal Education, which is a law school among others, equally have supported the administration of criminal justice. How? Before coming in place of the government of President Muhammadu Buhari, there were over 10,000 backlog of lawyers that could not be admitted into the law school, on account of the fact that there were over admission by the universities. And President Muhammadu Buhari insisted and demanded that, considering that they have studied law, facilities must be put in place for them to now be called to the bar. And that backlog is aggressively being addressed by the Council of Legal Education. This, in essence, establishes a sensitivity on the part of the president in terms of educational pursuit of the citizen. Copyright Commission is equally another institution or commission under the supervision of the Federal Minister of Justice, and the commission has also conceptualized and executed programs whose primary objectives are changing the copyright narratives and advancing the growth of the creative industry in Nigeria to enhance economic development of those that are involved in the services associated with it. So in fulfillment of its mandate, between 2019 and 2021, the Commission seized about 95,068 pirated works with a monetary value of 84 million. And indeed, the Commission also supported the development of copyright e-registration system, which enables copyright owners to register their works online with the Commission from any part of the world. Development of pilot edition of the National Works List, which is the database works deposited by the right owners with the Commission. So, by way of conclusion, let me state that what the Federal Minister of Justice do is not limited and restricted to direct supervision, but general coordination of the law enforcement agencies, which in effect gave rise to a global picture of the justice sector reform program of the federal government. So in conclusion, I wish to state that the ministry has relentlessly been contributing its quota to the running of government, and fulfilling the promises of delivering good governance based on rule of law and sound democratic values in accordance with best practices. I thank you most sincerely for listening.
Very distinguished ladies and gentlemen, in the course of the presentation of the Honorable Minister of Justice and Attorney General of the Federation, he was able to share very useful and important information. Of course, you will agree with me that correct information brings clear thinking, and clear thinking helps Nigerians to make sound judgment. To me, it was an excellent presentation, an excellent delivery at the same time. Let's give the Honorable Minister of Justice another round of applause. Thank you very much. Very distinguished ladies and gentlemen, I know the Attorney General of the Federation is the custodian of the law. And at the same time, he acts in the public interest. I also know that the media, apart from their information, education, and entertainment function, they serve agenda on matters of public interest. If you sum all these interests all together, it is for the national interest of our great nation, Nigeria. At this point, very distinguished ladies and gentlemen, we are moving into a very important segment of this engagement. That is the question and answer section. This is specifically meant for members of the press. Please, I noticed that some of our journalists just came in while the program was on, but please let me lay it again to you. When you are recognized to speak, you tell us your name, the media organization you are representing, and please restrict your questions or your comments to the issues addressed by the Honorable Minister of Justice and Attorney General of the Federation in his presentation. Please let us have one house to enable us to have a robust interaction. Having said this, I want to declare the floor open for your questions, please. 1, 2, 3, 4. Okay. Please give the microphone to the first person, please. Thank you. Hello. The Honorable Minister of Justice, my name is Yusuf Ali. I work with the Nation newspaper. Were it possible, we will have decided and accused you on the spot, but we have to do our job as journalists. Our respected director, my colleague, said I should tell you, you have always been saying that we just came in. We started with the Honorable Minister, we have not been coming late. So please try to always avoid that. Sir, I want you to clarify a few things. It might not be questioned as such. Recently, some conflicted former governors were pardoned by the federal government. Also recently, a public officer was alleged to have looted 109 billion naira. In his own wisdom, he pleaded for plea bargain and he returned 30 billion naira to the EFCC. Yet, a poor man will steal 10,000 naira. He will be jailed for 2 or 3 years. Are there two laws this country. Thank you. The next question, please.
Yeah. The Honorable Attorney General, Minister of Justice, and senior government officials on the high table. My name is Sonny Daniel. I work with Vanguard District. We need to comment what you have done, because in this country, we were here when Nigeria was noted for arbitrary arrest, detention of people, disappearance of people, and so on. And Nigeria had a very bad image internationally. So what people have done to change the story, and then train a system of human rights where people, only those who have committed offenses are punished and innocent people go about freely, is something we must commend. Having said that, sir, I need to find out from you the PIB case, a PNR, where has Nigeria reached? Is it that Nigeria has been freed? The liability is written off? Because I understand that some of the suspects in the case have been prosecuted by Nigeria, some have been sentenced. So if the suspects have been sentenced, what happens to the case? So you need to brief us on the status of that case. Thank you very much.
Okay, Punch, then we go to Guardian, please.
Yeah, my name is Adilani Adipiban. I write for the Punch newspapers. In 2018, the president signed an MLA with the UAE. Shortly after that, there was an investigation indicated that about 334 Nigerians had properties in Dubai, and some of them were believed to have been acquired with proceeds of corruption. Commendably, the office just applied to the court and seized the properties of the former Senate president. We must commend you on that. But what happened to the other 303 individuals who also have properties in Dubai? Some of them are governors, ministers, presidency officials, and even lawmakers. That's number one. Secondly, last year, the Punch reported that some officials in your ministry were selling federal government property, and significantly you set up a committee to investigate the report. Since then, we've not had anything about it. We would like to know what were the measures taken to prevent this in the future. How many officials have been sanctioned? Thank you.
Yeah, thank you, Honorable Minister. My name is Bridget Onochie, and I'm of the Guardian newspaper. So I want to thank you for all you've done to make Nigeria a human rights compliant nation. But I want to take you on one more thing. There's something left undone, and that is what concerned Nigerians are calling refusal to deposit the special declaration of African Court for Peoples and the Human Rights. That's Article 34.6. I know that the court had come all the way from Arusha to Nigeria. They have written letters. They have done everything they could to make Nigeria deposit that special declaration, especially because of the strategic position it holds in Africa. Now, only 9 countries or 8 have deposited. But they believe that the very moment Nigeria deposits, other African nations will follow suit. What exactly is the reason for this delay? Thank you.
Please take it to the man in glasses at the back.
Sir, my name is Amadin Uyi. I'm with New Central Tele. I'm with New Central Television. So when you talked about justice sector reforms made and spearheaded by your ministry,
I expected you to shed light on the Administration of Criminal Justice Act. I know that that act has responsibilities expected from the judiciary and also from the executive, and several government agencies who are under the executive who have a role to play. It's been discovered that so many of them either lack the capacity or lack the funds to ensure that they play their role effectively in implementing the provisions of ACJA. And this is frustrating the promises you have made for speedy dispensation of justice and to ensure that Nigerians get justice as at when due. I want to know what the ministry is doing about that. I had expected you to shed light on it during your presentation. Then secondly, the Freedom of Information Act. I know the ministry thoroughly follows agencies, departments, and the ministries that receive requests for the Freedom of Information Act, their compliance and non-compliance. But over the years, we have seen that while the ministry has this information, so many government agencies who receive these requests and refuse to comply, nothing is done. We want to know if the ministry intends to take this up in the future to ensure that that FOI is complied with effectively. Thank you.
Thank you very much. Honorable Minister of Justice and Attorney General of the Federation, you may wish to provide answers to all the questions asked. Thank you very much, Honorable Minister.
Thank you very much, distinguished members of the press. I will start by addressing the first question asked by Yusuf Ali of the Nation. And I think the question simply put is whether there are two laws operating in Nigerian state, in view particularly of the fact that he said certain governors that were convicted were granted pardon, and then perhaps cited an example where someone accused of perhaps corruption of associated with over 100 billion is engaged in plea bargain, while someone accused of a trivial or menial, perhaps trivial offenses running into thousands were indeed sent to prison. Well, the summary of the answer, or my reaction to it is there is a single law operating in Nigeria, and that law is applicable both to those that have and those that do not. Perhaps maybe the only difference which I can gather from his question is someone accused of 109 billion can certainly not be equated in quantum sense with someone accused of perhaps maybe of infraction associated with 1,000. But in the spirit of the subject matter of the law and its application, the state pardon, for example, where a pardon or perhaps application request or perhaps application of same is considered by the president, it is not the quantum or the volume of the money or infraction involved that matters, but whether within the context and spirit of the law you are indeed eligible for consideration. So the idea in effect is not whether what you have looted or squandered or the amount involved is 1 billion. It's not the 1 billion that is in consideration, but the ingredients, elements associated with pardon. So someone that is accused of 5,000 naira is certainly bound by the same criteria, the same considerable elements in the exercise of pardon and discretion with the one that is accused or perhaps maybe convicted in respect of an offense bordering on 1 billion. So what I'm saying, there are no two sets of laws, but there could be a variation in terms of volume of the subject matter involved, and it is not the volume that is involved, but the ingredients of the exercise of discretion. So what I'm saying in essence, there has been in place a legislation. That legislation tolerated and accommodated pardon, vest discretion of the president to exercise pardon. So the question is whether the president has exercised the powers vested in him constitutionally or statutorily or not. And my answer is, regardless of the volume of the money involved, the major consideration is judicious exercise of the power by the president. And my answer is, Mr. President has been exercising the powers statutory vested in him as it relates to pardon without necessarily having regard to the volume involved, but the law and its compliance. So that, I hope, answers your question. The law is one. Its application is universal. Its enforcement is equally general. Now, Mr. Sonny Daniel of the Vanguard raised issue on P&ID, I suppose, and had wanted to know, is it what is happening on whether, where are we? Well, P&ID has two dimensions, international and local. In respect of the international dimensions, in the course of my submission, I stated what successes are recorded, inclusive of the fact that we have succeeded in staying the execution or enforcement of the arbitral award of 10 billion against the Nigerian economy, which has the capacity to undermine the total economy of the country. And locally, there are issues associated with it, in respect of which inactions on the part of some individuals, personalities, officials, and otherwise were alleged, and then prosecution in that respect is ongoing. So the sum total is we have recorded successes internationally. The last part of the P&ID case is being, the hearing in respect of it is coming up on 16th of January 2023, and locally those that are in one way or the other considered to have been liable in infraction sense are being investigated and prosecuted. Now, I think there was a component on human rights raised by Sonny Daniel. Is it? Oh, okay. Oh, that is commendation. I will thank you for the for commending the government in being alive to its human rights response. A reporter from Punch raised issue on possession of looted assets. Is it? Sorry, Punch, can you please come up again? Let me be clear as to what you are asking for. Okay. Sorry, my mind is refreshed over it. Thank you. We talk of an issue that borders former the Senate leader, Ikore Madu. That matter, at any rate, is a matter over which I wouldn't like to comment, considering that it is subjudice, it's local and international. And I believe you rightly know the provision of the law that when matter is pending before the court, as a chief law officer of the Federation, I'm not expected to comment one way or the other in such way and manner that it could prejudice the pendency of the proceedings going on in court. The court has taken possession, taken jurisdiction over the matter, is being litigated often. I wouldn't like to comment one way or the other. I'm sorry about that. And we equally raise an issue relating to asset investigation with particular regard to the looted assets or perhaps asset disposal in the office of the Attorney General. Well, you know, investigation is not a one-day affair. And when issues were raised by people, inclusive of the punch, I believe. A formal correspondence has been generated to Punch requesting Punch to come around and support investigation, if I'm not mistaken. Certainly there was a formal correspondence to Punch requesting for their support in the investigation because there were allegations that looted assets or perhaps recovered assets were being mismanaged then in the office of the Attorney General before the coming in place of the Proceeds of Crime Act, which was indeed the product of the executive. So for your information, when the Proceeds of Crime Act was put in place, there was provisions therein that now requested to having in place directorates in the respective ministries, departments, and agencies of government involved in recovery, involved in management and disposal of the recovered assets. So in compliance with the law, the Attorney General of the Federation directed that all assets that originally emanated from ministries, departments, and agencies of government be returned back to them for disposal in line with the processes established by Proceeds of Crime Act. And those assets were eventually returned to the Ministry's department. It was as a result of that decision that EFCC in the last 2 weeks engaged itself in the disposal of assets. So the assets that constituted the basis for investigation were returned to ministries, departments, and agencies of government involved in their recovery originally. The allegations are as well being investigated by EFCC because the Office of the Attorney General forwarded the letter written by Punch and some other petitions generated from different, from different sources to the EFCC to investigate. And then the EFCC is investigating same, but then it's not a one-day affair. And then after the investigation, the Federal Ministry of Justice or perhaps the necessary offices of government will now be instructed and directed to do the needful. So nothing is swept under the carpet. There is no carpet existing in the office of the Attorney General anyway. Yes, any other question? Oh, okay. Okay. Mr. Amadi of News Center TV, I believe, right? Equally raised issue of administration of the Administration of Criminal Justice Act and expressed concern that the administration, I have not, in the course of my submissions or presentation, done greater justice to administration of criminal justice. I'm not sure whether he was indeed among the latecomers, but at any rate, I mentioned Administration of Criminal Justice Act and how it was indeed deployed in the act of ensuring speedy determination of cases. But then, for your information, we have not only first the Administration of Criminal Justice Act, put it in place, its enforcement in place, but equally encourage, work with the states at the national, at the subnational level to ensure the domestication of the Administration of Criminal Justice Act in view of the fact that it has greater good in speedy determination of cases. And a lot of states, I think as today, over 28 states across the Federation have domesticated Administration of Criminal Justice Act, and that will further enhance the quality of justice delivery with particular regard to speed, among others. So for your information, I want to reiterate to your hearing, in case you have not heard before, that Administration of Criminal Justice Act is in place. Its spirit has been deployed and enforced by judiciary and the executive. It has been domesticated by over 28 states across the nation, and we are all working aggressively in terms of enhancing justice delivery with particular regard to its application and operation. We equally raise issue relating to Freedom of Information Act. What I want to tell you about any other law being enforced in Nigerian state is the fact that we are mindful of its application and operation, and that is the That is the more reason why we have in place monitoring and implementation committee, which has been over time, ever since its establishment, putting across suggestions for us now to consider and then ensure at the end of the day that effects are given to laws. For example, when we talk of terrorism prevention and prohibition act, among others, for example, the need arose arising from the suggestion by the monitoring and implementation committee to have certain practice directions, and we approached the judiciary, the Federal High Court, we worked with it, and practice direction was equally put in place. So what I'm saying in essence, we are indeed working, we have been monitoring, we have been implementing, and we have been enforcing whatever law is put in place. And if to your mind you think there is need to do more, you can always approach us, and they will be willing and ready to accommodate your suggestion. We do not sweep suggestions, opinion, observations under the carpet, and that is the more reason why when Punch raised the issue associated with Interministerial Committee on Disposal of Assets, we now invited them formally, even though they declined appearing. I have to state that they have not done justice to the investigation by refusing to appear. But then, notwithstanding the fact that we invited them to clarify, to shed more light with the decline, we took a decision to now refer the matter to investigation by the EFCC, and the EFCC are now being the needful in terms of that investigation. So what I encourage the members of the press to be doing is not only perhaps maybe to engage the public space in terms of allegations. If you are called upon to shed more light, please do. And that is a better way to work in collaboration. But you now raise an issue, far-reaching issue, accusing the office of the Attorney General of wrongdoings. You are invited to come over, shed more light. You are not coming. What are you doing? What are you saying in essence? So thank you most sincerely for all the questions raised, and I rest my case. Thank you.
Honorable Minister, I think there was a question from Guardian newspaper that you have not answered.
What was the question, please? First, let me establish the point that as a government, as I've stated in the course of my submission, we have established a reputation of respect for human rights, a reputation that we are the only government in history of Nigeria that indeed complied, acted on the submissions and recommendations of the Human Rights Commission in terms of payment of compensation. So we equally establish a tradition of looking at international conventions that are beneficial to the nation and work on them. I have cited by way of an example the Budapest Convention, in respect of which cybercrime convention was indeed ratified by Nigeria. So what I'm laboring to state in essence, that whatever convention, whatever treaty is in place, or perhaps is presented for our consideration as a government, we look at it from the perspectives of Section 174 of the Constitution relating to the responsibilities of the Office of the Attorney General, the public interest. So the human rights instrument you are talking about is being subjected to the analysis of the public interest, the interest of justice, and ensuring at the end of the day that no abuse is allowed to set into our discretion in the justice sector administration. We are studying it, and there is no limit and time on studying it, and then we will act when we feel it is in the best interest of the nation to act. Thank you very much.
Honorable Minister of Information and Culture, we wish to make some comments.
Thank you very much, Honorable Minister of Justice and the General of the Federation. I've been unfairly accused of condoning time extension for the Attorney General, and I think it's very unfair. We've been very, very democratic on this table. We are 4. 3 of us are lawyers. We decided to support ourselves. Secondly, my warning is that never give a microphone to a lawyer or a politician. Fortunately for us, Attorney General is both a lawyer and a politician. Thank you very much.
Thank you very much, Honorable Minister. Gentlemen of the media, we want to thank you for your time. This is the note we can take for today. We want to thank the Honorable Minister of Justice and the Attorney General of the Federation, the Solicitor General, the Permanent Secretary. Very distinguished ladies and gentlemen, we have come to the end of this engagement. May we please rise as we take the national anthem, please. Thank you, and God bless you all.